Ladies and gentlemen, welcome to this BUL International Law Group event on state responsibility and current developments when it comes to international dispute settlement. This event coincides also with the first anniversary of the war in Ukraine, so inevitably issues that pertain also to the war are going to be presented in the course of our discussion. The event has been organized, is being chaired by Dr. Gerard Conway from Brunel University London. And with no further delays, I pass the podium to him in order to introduce to you the speakers that we have today for you. For my part, just to let you know that questions are going to be posed to our speakers after the presentations are finished, and they can be posed in written by you in the audience in the Q&A section that you see here in the Zoom room. Dr. Conway, the floor is yours.
Thank you, Solon, and thank you to both Solon and to Patricia Hobbs, who unfortunately cannot be here today as she had planned. Solon and Patricia are the directors or coordinators of the International Law Research Group at Brunel. We have quite a lot of international law research in the law school. So while I invited the speakers, they did the rest and organized the Zoom and made all these practical arrangements. I'm very pleased to have our speakers here today. I think it's fair to say that it's a distinguished panel that we have. So what I would like to do is to just say a few words briefly about the theme of the seminar, and then to introduce the speakers, and then we'll begin with each contribution. I leave it up to each speaker to decide if they would like to take questions directly after their own contribution, or if they prefer to wait till the end. So I'll let them organize that. Well, as Solon said, it's the first anniversary of the invasion and of Ukraine by Russia, and so that might seem like a failure of international law, but the response of the international community has been all framed around international law, and it's many aspects of the subject are illustrated by that. And our first speaker, Professor Alain Pellet, is going to address, if you like, the most general part of the international system relating to dispute settlement, state responsibility. Many of the attendees and audience will already know Professor Pellet, if they do not know him personally. He's one of the most eminent of contemporary international lawyers. He has been the chairman of the United Nations International Law Commission. He's Professor Emeritus at the University of Paris Nanterre. He's also president of the French Institute of International Law, I understand. And he's been very active as an arbitrator. He's like all our speakers, he's a prolific author. He's including the 9th edition of one of the main textbooks in French and public international law in 2021, and many articles in and chapters in prominent publications. I think he has a very broad experience of both academic and the practice of international law. Our second speaker, Professor Malgosia Fitzmaurice, is Professor of International Law at Queen Mary University of London, and welcome back to her. She has been through Brunel before in person the last time, I think. She's a very prominent expert in international environmental law, but she also writes about general international law. And she's going to discuss today some particular aspects of dispute settlement in environmental law. She's published a monograph on aspects of environment, on whaling in international law, and she's also co-authored a book on treaties in international law. So she has a very wide knowledge of what she will discuss. Professor Marko Milanovic is our third speaker today. He is, I don't think anybody will mind me saying, a younger scholar in the discipline, but he's also become very well known over the past 15 years. He is Professor of International Law at the University of Reading. He is one of the editors of the EJL Talk Online, and so many people know his name from that, as well as from his publications. He's a specialist in international human rights law, and including the extraterritorial application of international human rights law, which was the subject of his monograph. And he's going to discuss today this particular recent developments in this aspect of practice under the ECHR. So we have a general theme to introduce our seminar, which is very broad in its theme. The theme of the seminar is very broad. We start off with Professor Pellet. And thank you once again to all our attendees for being here today. Professor.
I can go now?
Yes, please, Professor Pellet, please.
Yeah, thank you very much. And I must say it's a pleasure to be with you today. And I thank the organizers for this occasion to have this debate with my good friends and esteemed colleagues, Malgosia, Fitzmaurice, and Marko Milanovic. Well, both of them have chosen rather to focus on specific and very actual topics, state responsibility or international responsibility. I will deal with a much more general and probably less exciting topic, and I will very briefly recall the general evolution of the law of state responsibility, mainly state responsibility, from pre-ago. Pre-ago, that means before the very stimulating renewal of the thinking and the very concept of international responsibility, promoted by one of, I think, the greatest internationalists, international law specialists of the last century, Roberto Ago, an Italian professor. I will start before Ago until today, and I will insist on the recent case law in general public international law, mainly the case law of the ICJ. Of course, this is a very, very vast topic, subject matter, which I can only touch upon, but hopefully it will put our debate in more in a general perspective. Well, as you know, it is today commonplace to accept that, as stated in Articles 1 and 2 of the ILC Articles on responsibility of states for internationally wrongful acts, and by the way, we had a very long debate to decide on the very title of this topic, of these articles. It is now accepted that every international wrongful act of a state entails its international responsibility. That is Article 1 of the Articles adopted by the ILC in 2001. And that, Article 2, there is an international wrongful act when conduct consisting of an action or omission is attributable to the states under international, and B, constitutes a breach of an international obligation of the state. In other words, this means that the responsibility of the state is entailed, but this is also true for international organizations, but I will let them besides, and for other subjects of international, the responsibility of the state arises under international law when two necessary but sufficient reasons are met. One is that an international wrongful act has been committed, and the second is that this act can be attributed to a state or to any other subject of international. Well, this may seem rather obvious, rather logical, but in fact, it is extremely novel compared with a traditional approach according to which state responsibility was analyzed as civil in nature. For me, it has always seemed stupid, but it was not. It was really the dominant mainstream analysis until Ago. But the traditional approach was that state responsibility was analyzed as civil in nature, that is purely intersubjective, and you needed, and it was in line with what could be called the Westphalian conception of international relations, and also it was, I think, a capitalist conception of law based on an absolute conception of sovereignty. And at the time, and until Ago, until the conceptual revolution by Ago, for responsibility to be incurred, four, not two, four conditions were to be met. First, a breach of an obligation, like in Ago's view. Second, it had to be attributable to a state, okay? And these were the traditional two other conditions. The breach had to have caused a damage, and this damage had to be caused to another state or another subject of international law. This was, in fact, reducing the responsibility of the state, and beyond that, international law as a whole, to very little. According to this, to that view, it was not a question of enforcing the law, but of being able to buy a violation in exchange of damages, of paying money or compensation. In practice, it is still true in quite a vast majority of cases. But I think really that, and I have always been convinced by Ago's approach, that responsibility cannot be thus limited to the obligation to make reparation. The International Wrongful Act calls into question the security itself of legal relations, and it is rightly, in the modern conception of the term, which we again owe to Roberto Ago, that the term international responsibility applies to the whole range of new legal relations which arise in international law from the International Wrongful Act of the state. Its purpose is not simply reparation for the damages resulting from a breach of the law, but it is also, of course, it is true that reparation is an important part of responsibility, but it also aims at preserving the integrity of the law. Exactly like in the domestic law, you are held responsible if you run a red light, even if you haven't bumped into anyone or not an old lady or a dog. And for a purely subjective, intersubjective conception, we move to a partly objective and communitarian vision of responsibility. And behind this, because responsibility is really at the heart of international law, any law, I think. So beyond the pure new concept of responsibility, we move to a new vision of international law itself. This new way of thinking was inspired and inspires the articles which were adopted in second reading in 2001 by the International Commission under the very able impulsion of my most regretted friend, James Crawford, who is, after Ago, I would say the second father of the ILC draft. In particular, because respect for legal rules is a concern of the international community of states as a whole. Responsibility in the 2001 articles is not limited to a purely bilateral relationship. The articles make a distinction between, on the one hand, the immediate legal consequences of an internationally wrongful act, which are cessation and reparation. And on the other hand, the article also accept that the invocation of responsibility by states, that states other than the injured state can invoke the responsibility of a state, and this is clearly said in the very, very important Article 42 of the Articles. And also, according to Article 48, any state member of a group to which an international obligation is due may engage the responsibility of the wrongdoer. Well, now, the law of state responsibility has always been praetorian in nature. It was the arbitral tribunals that set up at the end of the 19th century and beginning of the 20th century, which laid the foundations of the law of state responsibility, especially in cases between European states or the United States or the USA and Latin American countries. And it was clearly an imperialist enterprise. The aim was to force the Latin American states to make reparations for damages, which was not self-evident in the law in force at the time. And it was the permanent court, the PCIJ, that fixed the law of state responsibility as elaborated by the arbitral tribunals, the Latin America, European states context. It was a PCIJ which fixed that law in a well-struck formulas, that have become now the vulgate of liability law, responsibility law today. And to a large extent, the ILC has taken note in its articles of this law of jurisprudential essence, without contesting the fundamental elements and merely filling up certain gaps, removing uncertainties while adding a cautious but I think welcome zest of progressive development. But the interaction between courts and tribunals, and in particular the word court, and on the one hand, and the codification process on the other hand, has not ended with the adoption of the 2001 article. The ICJ merely noting on an ad hoc basis that this or that provision of the ILC article expresses the state of customary international law for the purposes of the settlement of the precise case which is before it. And I think that the ICJ rightly considers that it is not its role to decide whether globally the ILC articles reflect customary rules as a whole, although it is true for, I would say, 80% of the draft articles. Thus, up to now, the court has not had the opportunity to take a position on the advances constituted by some of the most important provisions of the ILC articles, and notably Article 33, 40, 41, 42, 48, 54, which for me are the most interesting ones in the ILC articles, which have not always been very welcomed by states, but which I think are very, in fact, prudent and acceptable development for international law. These are the articles which entrench the concept of international community in the law of responsibility, and which draw some consequences from it. But even while the Word Court has not taken positions on them, some important tribunal arbitral decisions have, including the PCA awards of 2015 in the Arctic Sunrise case between the Netherlands and Russia. This was on Article 42, or the PCA award of 2020 in the dispute concerning the coastal rights in the Black Sea. This was on Article 41, or again in Arctic Sunrise and in the ITLOS advisory opinion of 2011. Well, on the other hand, the ICJ itself considered that many provisions expressed the positive law, that is a law in force. And in applying these rules, the court, I think, has provided quite interesting and useful clarifications on the interpretations and scope of these provisions, in particular, with regard to the system of international responsibility itself and the notion of internationally wrongful act, with regard to the attribution of such an act to the state, and with regard to the concept and implementation of responsibility. I must say that with the efficient assistance of my assistant, Sam Swirly, we have systematically identified all the decisions of the ILC and of the ICJ, and other interstate courts and tribunals applying and prolonging the 2001 articles, but I see that time is running out, and I cannot go into detail about these developments in the short times I have hopefully still available. I will write an article on the topic. Just a few topical recent examples by way of illustrations. In the 2005, I just started in 2001 after the adoption of the articles. In its 2005 judgment in DRC versus Uganda on armed activities, as well as in the two genocide cases, the court provided very useful clarifications concerning Article 4, conduct of organs of a state, 5, conduct of persons or entities exercising elements of governmental authority, Article 8, conduct directed or controlled by a state, 10 on the conduct of a movement establishing a new state or insurrectional movements, or 16, which relates to the aid or assistant in the commission of an international wrongful act. In particular, in the genocide cases, both Bosnia and in the two genocide cases, court clarified, and this clarification was much needed, the contour of the obligations to prevent, which is a big vague in the ILC articles, In the Wall advisory opinion also, the court clarified the circumstances in which the excuse of necessity could be invoked as a circumstance precluding wrongful acts, as codified in Article 25. And interestingly, Article 25 itself is directly inspired by the court's judgment in Gapshikovo and Aguimaras. Another example, you cannot now deal with reparation, notably Article 31 et sequitur of the ILC articles, and in particular Article 38 on interests for compensation, without mentioning the court's jurisprudence or case law. And I must say it is very useful, because my view of Article 38 is that it is one of the failure of the ILC. The ILC has not been very serious in dealing with interest, in spite of my insistence to James Crawford. Of course, the international law of state responsibility, or more widely of international liability, also developed beyond the framework of the 2001 articles, notably concerning the diversity of legal subjects liable to incur responsibility. I think that it is now indisputable that international organizations are responsible for their internationally wrongful acts. And as you know, the ILC adopted draft articles codifying this topic in 2011. And I must say that these 2011 articles are in large part carbon copies of the 2001 articles of state responsibility. And I personally always disapproved the fact that the ILC didn't just copy the state responsibility in the international organization responsibility. I think they are very different phenomena. And also now it is clear that the responsibility of private persons, including individuals, of course, in international law is clearly accepted, even if it is not the subject of any general codification text. But my co-panelists will no doubt give very interesting example of this. They will also certainly illustrate another aspect of the law of international, the new law of international responsibility, which I consider as very fundamental, and that the great success of the ILC Articles of 2001 must not conceal. That is a diversification of the forms of international responsibility or liability or accountability or even answerability. In French, we have only one word, responsibility. Fortunately, English is much nuanced, and I think all these different aspects put the accent on different views. Indeed, just as international responsibility cannot be limited to that of the state, it cannot be limited to that which may be incurred before a court. I think that soft law corresponds to forms of soft responsibility, just as by definition, a recommendation does not oblige its addressees to do or not to do something. So if they do not comply, if the addressees do not comply with a recommendation, they are not liable for reparation. But this does not mean that nothing happens. By deviating from the recommended norm, the state or other subjects of international, who are the addressees of the recommendation, expose themselves to soft reactions from their partner or from the recommending international organization. I suppose that Malgosia, Fitzmaurice will go in some detail on that because the environment law is really the ground for that. I am short of time. Before ending this brief, which you see as a topic, this brief and large panorama altogether, some quick words by way of provisional conclusion, if I may. Going back to the more classical field of state responsibility for internationally wrongful act as codified by the ILC in a very convincing, I think, modernized approach, as well as the use of the ICJ has made of the articles up to now. I have four main points. First, after a period during which it had relatively few cases involving the international responsibility of the state, it is true that it was size of a few cases at all. These cases now on responsibility now share the court's role more or less equally with land and maritime delimitation cases. Little bit more for delimitation, bit less for responsibility. Personally, I am a frequent pleader before the court, and I much prefer responsibility cases, which I find much more amusing and entertaining than delimitation cases. Second, generally speaking, the court applies, whether openly or not, the rules developed by the ILC and contained in the articles adopted by the latter in 2001. These rules being themselves largely derived from the case law of the World Court. But when the court reaffirmed these principles, I think the legal value of these rules is reinforced. Third, the generality of the articles and their non-legally binding nature has the added virtue of allowing for additions, adaptations according to needs and circumstances. And as a recent case law of the court shows, the ILC has fulfilled this task authoritatively and, as a rule, very satisfactorily. The 2001 articles are really a guide, very trustful, very useful for the law of international responsibility, even if it has to be completed and made more precise. Four, this all confirms, if it were necessary, that there is no need to conventionalize, to transform the ILC draft into a treaty. As they stand, the 2001 articles perfectly fulfill their function as a guide for state practice and for the case law of international courts and tribunals. And in this respect, and this will be my last work, very short, Mr. Conway, in this respect, I note that the UN General Assembly's relative enthusiasm for transforming the ILC articles into a treaty seems to be waning, and I am very happy with that. I think that the ILC had only its paid lip service to the idea of conventionalization, although a majority of its members were in favor, unlike James Crawford and me, but I think we were the only minority. And in its first resolution of the topic on 28 January 2002, the General Assembly noted that, and I quote, the International Commission decided to recommend to the General Assembly that it should take note of the draft article and the responsibility of states in a resolution and annex the draft articles to that resolution, which was done, and that it should consider at a later stage stage, in the light of the importance of the topic, the possibility of convening an international conference of plenipotentiaries to examine the draft articles with a view of concluding a convention on the topic. In that same resolution, the Assembly contemplated the conclusion of a convention on the topic at an unspecified date. And since then, that means more than 20 years later, the General Assembly examined the topic every 2 or 3 years, but it seems to have given up with the idea of convoking a codification conference, as witnessed by its last resolution on the topic of 19 December 2022, in which, after having taken up the formula adopted 20 years earlier, it adds that it could be envisaged to have a convention together with other outcomes. And I very much hope that other outcomes will be preferred than a convention, which I think is useless and would immobilize a law which has to evolve. Sorry to have been long. Thank you. Aren't you moved?
Dr. Conway,
Yes,
yes,
I've unmuted. Well, thank you, Professor Pellet, for a very helpful and I think very authoritative overview, both of the development of state responsibility and where it might go in the next phase. I took 2 pages of notes and picked up quite a lot from what you said. I'd like to ask you if you would like to take questions now, or would you prefer to wait until the general discussion at the end? It's up to each speaker if you would like to have questions now. Professor Pellet, can everybody hear me? You can hear?
I am open to, yes,
Yes.
I am open to any questions.
Well, maybe we can quickly take questions now because it's easier to remember things quickly after you hear them. So if anybody in the audience would like to ask a question, please do. I have a question, but I think I'll wait until the end, till the general discussion.
Or maybe Dr. Conway, we can start with our own questions here, the panelists.
Okay.
The audience can join if it wants.
Yes. So Malgosia or Marko, if you would like to say anything or to ask a question.
Maybe Alain, maybe I can ask you a question. So on your very last point about whether there should be a treaty or whether there should not be a treaty, I still remember this very powerful and persuasive article written by David Caron in the 2001, I think, issue of the American Journal, where he said that there's a paradoxical relationship between the form of the articles and their authority. And that in fact, because they're not a treaty, that's why they're going to be used so much. And I think you agree with that basic point, right? That actually putting them into a treaty would harm the basic purpose of the articles, would make them used less rather than more. Is that basically the argument I think that you would be making?
It is one, for me it is, it's okay. For me it is one of the arguments. I wouldn't say it is the argument, Marko. I think that for me and for James as well, were the only ones of this opinion in the commission. The idea was more than we were a bit defiant against the states. We think we were more progressive, more imaginative and more adapted to the real needs of the international community as a whole than the state would be. And we were afraid that conservative states, I remember discussions with Crawford, conservative states as the United States, as Russia, well, at the time Russia was less conservative maybe, Israel, a lot of the states who are definitely conservative in international and not very much interested in the international community of states as a whole, would really try to empty the progressive development aspects of the articles. And this was, I must say, my main point, and I think also Jim's main point. But it is true also that, but if it were really what your or Karen's view point, which was most important, I think it's not completely logical, because whether you invoke the convention or the ILC article, provided that these articles are not totally empty of their added value in the convention, why not? The problem is, of course, that if you have a convention which is not ratified, it could also lessen the importance of the ILC articles. While now, well, now I must also say that the court is very conservative, usually quite conservative, probably less than the Sixth Committee, but until now they have always been prudent. If you read between the lines of the judgments, you can see that they are not insensitive to the Article 42, Article 48, Article 54 orientations to the international community of states as a whole. And I have not given up that at some point I could induce a court or oblige the court to take some more progressive position than it has now. Malgosia, I think, would like to.
Malgosia, yes.
I have a question, if I may. I would like very much to know the view of Professor Pellet on something which is also very much connected to my research interest, i.e., whether it is possible to resolve the question of relationship between law of treaties and state responsibility, especially in relation of circumstances precluding wrongfulness, like state of necessity, force majeure, and the Article 62 of the Vienna Convention, and also 61. We know that during the drafting of the Vienna Convention, there were already problems with it, and the special rapporteurs like Fitzmaurice, they knew that this is a problem. They left it alone. They obviously said that Vienna Convention does not regulate state responsibility, but the case law, Gabčíkovo-Nojomaro's case, arbitral tribunal in Warrior, Rainbow Warrior, for instance, and air services arbitration, in my view, have not fully resolved this all the time, problems which come all the time, and basically very often states are confused what to plead, what defenses to put up. And I must say it's very much of interest to me whether it is solvable problem or it is not really, and if I may to ask for your view on that. Thank you.
Well, I must say it's a fascinating question, honestly. I think it is. You can hear me, Malgosia? Yeah? You can hear me, Malgosia?
Yes, everything is said, Professor Pellet.
Okay, I thought you were lost. honestly, I think it is a very fascinating intellectual and doctrinal question. I think there is a very easy way to answer. In fact, there should not be a Berlin Wall between both fields. Personally, I have in my general course of international law, I think you read French, Malgosia, so I can refer you to my general course in the Hague Academy. I devote some developments, if I remember well, to that question. And my view is that the debate between my regretted master Derek Bowett, my other regretted master Prosper Weil, on this question is really a vain debate. For me, there is no difference. It doesn't matter. When you breach a treaty, you breach both the law of treaties and the law of state responsibility. Personally, I think these are really quibbles. These questions should not be raised. But you are right to raise it, because indefinitely you raise it. And I am afraid that in the Greece versus Macedonia case, it was discussed quite at length before the Macedonian team and the Greek team, of which both James and I were members, and my good friend Bruno Sima wrote, I think, a very debatable, to be polite, opinion, which also touches upon that. But my answer is really straightforward. There should not be any difference between both. You breach international law, and whether it is a law of treaty, customary, that all this doesn't matter. It is said expressly in the responsibility draft, and I agree. James had more moderate views than I had. He accepted that there could be two different grounds, but at the end of the day, this I remember during the discussions we had in the in the Macedonian case. I remember that we agreed that the result was the same, but he said, well, intellectually it's different. I am less sophisticated.
Dr. Conway, if I can ask also a question to Professor Pellet before you ask your question, we proceed maybe with the next speaker.
Okay. Yes,
And so actually it's two questions, Professor Pellet, and the first has to do with externalities and compensation. We spoke about externalities. We spoke in the beginning of your presentation, you spoke about compensation, international responsibility. So my question has to do with the externalities facet. We know externalities.
With what we see?
With externalities in international law. And my question has to do, what's your opinion about the compensation of externalities, especially when it comes to fields like pollution, environmental law, or what I also research a lot, the civilian mental harm, the psychological aspect of warfare. This is one question. And the second question I would like to briefly ask, based on Professor Milanovic's also comment about the whole issue that we discussed about the convention, whether you think that your view crowns the prospects of soft law in international law as an alternative platform of creating international norms.
Well, at least the second question is unanswerable, because it's really all this vast and very fascinating field of soft law. As I said, but very quickly, I know that I overcome my time, but overpassed my time, but I decided for too wide a topic. As I try to explain, I think that personally, I'm a strong supporter of soft law. I think that soft law is law, and that it is extremely helpful, especially in international relations, and that sometimes the best is an enemy of the good. So I think that it is really a way to advance new behaviors, and that soft law norms are norms. They are indicating what is expected from the addressee. And as I said, I think that there also exists a kind of soft responsibility, exactly as there exists law which is said to be soft. It is sometimes less soft than it looked, and sometimes hard law is less hard than it looks as well. Here again, if I can make some publicity for those who can read French, I deal with this soft responsibility issue in my general course in The Hague. But in French, I have not the authorization to publish this court in English for 5 years. So I am waiting for the 2 next years, and then I will publish it in English and try to enrich it. As for your first question, may I suggest that we go back to it when Malgosia has made this presentation, because it's really environment, and maybe she knows these things much better than I do. I am a specialist of nothing, so it happens that I know a bit of everything, but not much. And she would be very much able than I would probably. But if not, I can give my opinion when she gives her.
Well, thank you to Professor Pellet for the answers, but also to our panel for posing questions. I think I could ask the audience briefly if they would like to ask any questions. Let me see if there's any. There are no questions in the chat. So, okay, well, maybe it's better to move on, and the audience can ask any questions they wish in the general discussion at the end. And also, I will make some brief kind of overall comments to finish off when everybody has spoken. So next, I'm glad to welcome Professor Malgosia Fitzmaurice, and she's going to discuss environmental law.
Professor Fitzmaurice, we are ready to hear your words.
Okay.
Yes.
I thought it was Marko.
We had previously actually talked about this, and we had decided that I would do the second one.
Oh, sorry. Yes. Okay. My mistake. My mistake. Yes.
Malgosia, do you want to go now, or do you want to go last?
It's up to. I thought we decided that you would go on now, but
that's okay. Yes, that was my mistake. Sorry.
Okay.
Professor Marko Milanovic,
Sure.
you will speak now about.
Sure, that's fine. Thank you so much. Can I first say it's a great pleasure to be with you all this afternoon, and thank you to Brunel for inviting me to speak about these very interesting questions of the law of state responsibility and how they work in the context of international dispute settlement in particular. And I want to talk about a very specific topic, which is attribution, the rules of attribution, in one very specific context, and that's when a state is being held responsible for the conduct of some separatist entity, a rebel group or something like that, administering territory on the territory of another state. So, for example, should Serbia have been held responsible for the conduct of Bosnian Serbs or Bosnian Croats? Should Russia be held responsible for the conduct of the Ossetian or Abkhaz authorities in Georgia? Should Russia be held responsible for the conduct of the Donetsk and Luhansk People's Republics on the territory of Ukraine? That's the topic I want to talk about. So there's really two separate questions, and I'll try to sort of distinguish them clearly. One is the issue of the legal standard being applied. the rule of attribution. And the other is the question of evidence. How do you prove the factual predicate for the application of the rule? And I really think those two need to be distinguished, and I will really talk about both of them in the next 10 or so minutes. So first, when it comes to rules, this really latches onto nicely to what Alain was talking about. These types of situations really emerged in two very important cases before the International Court of Justice. Interestingly, they were both cases in which Alain was counsel. So the first was Nicaragua versus the United States, which I think, Alain, may have been your first case, if I remember correctly, in the court.
Well, together with Burkina Faso, just exactly. At the same time, exactly. Which I find very important, but nobody speaks about it.
No, but we don't care about Burkina Faso. We don't. Yeah. And then there was the Bosnian genocide case. So in Nicaragua, as you all remember, the issue was whether the United States was responsible for the conduct of the Contras. In the Bosnian genocide case, the issue was whether Serbia, the Federal Republic of Yugoslavia, was responsible for the conduct of the Bosnian Serbs. And in these two cases, which also, of course, overlap with the work of the ICJ, of the International Law Commission, we have an evolution really of the approach of these two institutions to this kind of problem of a separatist proxy entity that is being influenced by some other state. And the court essentially says there are two different possible approaches to attributing the conduct of such an entity to a state. The first is to prove that the entity is a de facto organ of the state, that in reality it is completely dependent upon the state, that everything they do then becomes an act of the state in the same way as if it was done by a de jure organ of the state, an entity that had such a status under state's domestic law. But then the court says in both Nicaragua and genocide, if you can't prove this level of complete dependence, this very demanding test, then you need to prove that a specific action, a specific operation was instructed or effectively controlled by the state. So for example, in the Bosnian genocide case, the court first looked at grosso modo as a whole, was the conduct of the Bosnian Serbs attributable to Serbia, and said no. You know, they enjoyed a substantial measure of autonomy, even though Serbia had a lot of influence over them. And then asked, okay, was the specific operation at issue in the case, the Srebrenica genocide in 1995, is that attributable to Serbia under the Article 8 of the ILC Articles, Instructions, Direction, Control Test? And the court said also no. Serbia not only did not control that operation, they had no idea that the Bosnian Serbs were going to commit genocide. So that's really the two tests, the rules, as they were developed by the ICJ and the ILC in this very sort of complementary fashion. The rules apply and are relevant in many other contexts. Imagine, for example, the attribution of cyber operations by states, right? When cyber operations are conducted by hacker groups that are under some degree of state influence, but we don't know exactly how much. Or think about, you know, the conduct of the Wagner military, paramilitary organization. Is that in law the conduct of the Russian Federation? And is that the conduct of the Russian Federation because the Wagner group is completely dependent upon Russia, the first test, or because specific actions of the Wagner group are controlled or instructed by Russia? I hope you understand how hugely important these two tests are. Now, that's the question of what the rule is. Separate to that question is how you prove it. And in the ICJ proceedings, neither Nicaragua as the applicant nor Bosnia as the applicant, again, both represented by Alain, were able to prove that the evidence was there of this kind of instructions and control. And a lot of people criticized the court that the thresholds it set were too high, were too demanding, that they could never be met realistically, partly because as you can imagine, these relationships between states and proxy non-state actors are hush-hush. They are secret. They're operated by intelligence agencies. The evidence is normally going to be in the possession of the respondent state. It's not going to be easy to prove. So I will really talk about both of these questions of the standard and the evidence as they have appeared in two recent cases before the European Court of Human Rights. So that's really my presentation, if you will. The first case is Carter versus Russia. This is the case in which the European Court attributed to Russia the assassination of Alexander Litvinenko in London. So the court determined as a matter of international law, as it applied to the facts, that it was the Russian state that killed Litvinenko by poisoning him with radioactive polonium. And the court said the assassination was done by two private individuals at the time. The Lugovoy guy, I can't remember the name of the other. They were two private individuals. They were not de jure organs of Russia at the time. But the court applied expressly Article 8 of the ILC Articles to say that Russia instructed or controlled that specific act, the assassination of Litvinenko. And this is one of these very rare cases in which this article, Article 8, in an international courtroom is applied successfully, right? So the proof is made. Now, what's so interesting about the case is how the European Court of Human Rights approached this question of proof. We can talk about standards of proof, etc., which is sort of a separate topic that I want to get into. The court pretends it's applying a beyond reasonable doubt standard. It's not really that. But the main feature of the court's approach is this incredibly aggressive drawing of inferences, of adverse inferences. Essentially, situations in which the court says the burden of explanation shifts onto the respondent for various reasons. First, in the UK, when it comes to the Litvinenko killing, there was a judge-led independent inquiry that established the facts at great detail. Second, the two suspects fled to Russia. One of them became a member of the Duma, etc., etc. Third, there was a clear motive on behalf of the Russian state to commit the killing. Fourth, most importantly, it was the Russian state that had all the control of all the relevant evidence in its possession. And finally, the court said, we asked you for information and you gave us garbage. Nothing you gave us was even remotely persuasive. And so the court said, by drawing an adverse inference from the failure of Russia to provide a plausible explanation for what happened, you did it. Russia did it. Yeah? So that's the Carter judgment. Now, the Carter judgment, which dealt with the killing of one person, yeah, suddenly that approach gets applied on a vastly different scale in the recent admissibility decision in the case, the interstate case, the Ukraine and the Netherlands versus Russia. So this was a decision decided last month, yeah, where this is the one of the interstate cases that dealt with human rights violations of the European Convention in Eastern Ukraine from 2014 to the start of the new big war. Yeah, so it's the last or the previous 8 years, not the war that started exactly a year ago. And it also dealt very, very importantly for our purposes with the downing of the MH17 Malaysian airline. Yeah. Now, in this case, the court primarily deals with this question of extraterritorial application. Does the convention apply to an area, a territory that is not Russia, but that Russia might control. And the court says, yes, Russia controlled eastern Ukraine through its proxies, like the Luhansk and the Donetsk rebels. So there is a couple of interesting things that happen here from the standpoint of the law of international responsibility. The first, which I find very annoying and troubling, is that the court says, for the first time, it has until now been obfuscating on all these issues, that the conduct of these separatist entities, Luhansk, Donetsk, was even before they were annexed by Russia, from the very beginning, attributable to the Russian Federation. Now, why do I find that problematic? Because the court does not apply the International Law Commission's or the ICJ's standards of attribution. None of them. It doesn't even refer to them. And I really find that problematic, simply not because this is gospel, right? Not because the European Court of Human Rights has to follow what the ILC and the ICJ said, but simply because if you want to disagree with them, at least justify why you're doing that. Yeah. But then, and here comes the really good part, the court engages in the most extraordinary evidential analysis that I don't think any other international tribunal, certainly not the ICJ, has ever engaged in. So first, it sort of sets out in the decision its a general approach to questions of evidence and the failure of Russia to cooperate with the court's questions. And essentially, it accuses Russia, if you read the judgment, in language that the ICJ would never have used. The European Court essentially accuses Russia of lying to the court, of being deliberately deceptive, vague, uncooperative. Yeah? And it says we're going to draw adverse inferences from this type of behavior when you were in the exclusive possession of this evidence. I mean, to give you a very concrete example, one issue in the case was whether the leader of the Donetsk separatists at the time, this guy called Igor Girkin, who was directly involved in the downing of the MH17, who is now a commentator on the war, very, very prominent and so on. The issue is whether he worked for the FSB, for the Federal Security Service. The court asked Russia, tell us, was this guy your agent? And Russia refused to say so. Yeah. And the court will say, well, we're going to draw an adverse inference from that. And if you read the judgment, 120 paragraphs of incredibly detailed reasoning of all the kinds of influence that the Russian Federation exercised over the Donetsk and Luhansk separatist entities, including, for example, the staffing questions, including money, including weapons, etc. Now, after you read that evidence, I would think that even the court, the ICJ's very demanding complete dependence test in Nicaraguan Bosnian genocide would have been met. And it really, again, that's why I find it so annoying that the European Court didn't refer to these tests. Even that most demanding test, I think, would have been met on the facts and should have been labeled as such. So that's sort of the bulk of my presentation, if you will. There's going to be a lot of more attribution issues on the merits of the case when the court reaches the merits of the case a few years from now. In particular, it will be interesting to see how the court approaches the downing of the MH17. From what it has said so far, essentially the inescapable conclusion is that Russia itself downed the plane. Yeah? The court essentially already found that. The court already accepted as proven the findings of the joint investigative team, et cetera, on the downing of the MH17. And essentially from that, you would see that Russia provided not just the weapon, but also the crew of the surface-to-air missile system to the separatists. And I don't see how the attribution of the downing of the MH17 could be avoided. But okay, but that's that one case. What the question that I sort of want to raise, and this is how I conclude, is whether we can expect other international courts to be as aggressive on this question of evidence as the European Court of Human Rights. Somehow, I think the International Court of Justice, even in 2023, would not dare to do something like this. And perhaps it's the specificities of the human rights context which enabled this. But it is a really instructive case on just how rigorous, how punchy international courts can be on questions of proof. Thank you so much.
Thank you, Professor Milanovic, for a very specific and detailed discussion of the cases, but also linking them to previous discussion. So firstly, I'd like to invite the panel to respond or ask questions, and then I'll let the audience speak if they wish.
If there are no questions or comments from us, yeah, Professor Fitzmaurice, you can unmute and you can ask, yes. Professor Fitzmaurice, you're still muted.
You're muted.
Okay, thank you, Marko, for your really very interesting presentation. I have to ask you a question, which, you know, you gave a sort of analytical approach to different views and legal reasoning on this very difficult matter on attributability of wrongful act in such unclear circumstances, and different approaches of various courts, ICJ, criminal courts, European court. Do you think that at any point can be some consistency achieved by international courts and tribunals in interpretation of such situations? Because it's quite confusing in a way, and very, very difficult to follow. And sometimes reasoning is also quite confusing. And maybe I am not such an expert as you are in this, but I read quite a bit about it, and I find it very difficult to form a general picture of reasoning and final sort of decisions of courts and tribunals in such situations as you presented. Thank you.
Thank you, Malgosia. So I think it is possible to have a general coherent approach. I am personally a fan of a lot of what the ICJ and the ILC have said on these issues. I think it makes sense in broad terms, but we don't have that. So the issue is, why don't we have that? And there could be a number of answers. One is that for some reason, the specific subject-specific courts like the European Court of Human Rights think that the general rules are not a good fit for their particular regime. For example, they might be particularly demanding. I am pretty sure that's one concern in this on this specific issue. The other reason is that if you look at, for instance, the makeup of the European Court of Human Rights, most of the judges on that court are not international lawyers. They're domestic, Supreme Court judges and so on. They learn on the job, right? I mean, this is not rocket science, the stuff that we do. We're not neurosurgeons, right? So they can learn it on the job, but they don't feel also the same level of attachment that we have to issues of coherence and generality in international law and so on. So that explains, I think, quite a bit of the chaos.
Okay. If anybody else would like to,
I think Alain has a question. He has his hand up.
Yes, sorry, Professor Alain.
Well, yes, I really enjoyed your speech, Marko. And you have already prevented me to ask a question, because you at least gave an answer which is also very pregnant in my mind, that is that the European Court does not know at all any international law, since a Greek judge and former president has disappeared from the court. And clearly, as an international lawyer, I have real problems with the case law of the European Court. So this is part of the, probably part of the answer. They simply don't know that it exists. That said, the advocates and barristers are here to recall them, and I am not sure that advocates and barristers know international as well. This is part, but it is only part of the answer. I also think that the Nicaragua test, as you recalled, I was counsel for Nicaragua in the big case in the 1984-1986 cases before the ICJ. And honestly, we lost on that. Everybody thinks that it was a triumph for Nicaragua, but it was a semi-triumph because this was extremely important. And the so-called Nicaragua test was bad news. And I think it is wrong for the reasons you partly explained. That is that it is such a strict test, both as a general idea. It is just too general. And I don't know why each and every case and every violations of the law of the war, of the armed conflict should be proved, provided that you are in the hands and depending of the United States, or for that matter, Russia, concerning Wagner. I have another word to say about Wagner. And also, and you explained it very well, it is virtually impossible to prove that in each case you are and it was clearly true for DRC in the case of DRC against Uganda. In that case, it was in the bad sign, I think. But I think they could not prove that there was a real control of every atrocity committed by the Ugandan armies, or even more the mercenaries. So this is part, but also I must say I am usually I accept to lose before the court. It's the rules of the game, and I am not. James was furious because we met Canton, and I won more often than he did when we were opposed to each other. But I accept very easily that I was wrong in my pleading, and sometimes I know that I am wrong when I plead. But on the contrast, I have never digested that. I tried again in genocide in the Bosnia. I didn't accept to be Croatian for Croatia for various reasons. But in the first genocide case, I really tried hard, and I explained, and I think I was right. I think I am right, that at least for genocide, it is a global crime, and it is absurd to apply the Nicaragua test. For a global crime, you cannot demand that. I don't accept it for war crimes, but for genocide and for crimes against humanity, which need a global picture, what you must prove is a global control. It is absurd to request a case-by-case control, which is the Nicaragua test. So this is for my one of my rare criticism on important things against the court. On Wagner, it happens that I am writing a book which I hope will be published recently on the, but not alone, on the crimes on Putin's crimes. And I must say that it is difficult concerning Wagner, because Wagner, the chief of Wagner, I don't remember his name, Prigozhin, something like that. Yeah, is always complaining that he does not get the support he needs. But I think it's rather easy to say, well, he doesn't need but he's depending as well on and the very fact that he says, I don't get the support we need, shows that they are controlled by the Putin or by his associates. So personally, I think that it is a good thing to abandon, including in Carter versus Russia. It is a good thing to abandon the Nicaragua test, which was against by strong protests in the ILC, adopted by Crawford. Crawford is less. I am not an activist. I am a lawyer, but was less politically oriented than I am. And he was more indifferent. He said, well, the court has said so, so we must not oppose the court. But I don't care. Absolutely, I have no problem in opposing the court. And I do that when I plead. But I really think that this test is so absurd that it should not. And I am grateful for the European Court to have abandoned it, even though, as you do, I regret they have not really justified this. But again, probably because I am not sure they even knew it exists.
So can I come in on that? So they knew about the jurisprudence for various reasons. So one reason is that
you were pleading in that case.
Actually, yes, but so me and a colleague from Nottingham, Sangeeta Shah, we were granted permission to be amici curiae. So we submitted a third-party intervention, which dealt precisely with these issues. But it's not just that; it's also that actually, from these cases that deal with Moldova and Transnistria, Russia has been in many cases saying you need to follow the ICJ, because of course that would sort of go in Russia's favor. And in these cases, so the most important one is called Katan versus Moldova and Russia. The court said, no, we're not doing attribution at all. We're doing this extraterritoriality issue. We're not doing attribution. So we don't have to get into the jurisprudence of the ICJ. Whereas now they do attribution. So Alain, my one point of disagreement with you would be this. I think it's a mistake to talk about the Nicaragua test, because there's two tests. One is the test, did you control the specific act? The other is the complete dependence test, which is precisely as you put it, global. Did you control the actor as a whole? Yeah, it's just that that's much more demanding than, for example, the overall control test by the ICTY in Tadic. Now, I agree that it's demanding. I don't think it's impossible to apply. Again, if you read this judgment, like even the strictest application of the criteria in Nicaraguan Bosnian genocide, you would agree that the Donetsk and Luhansk People's Republics were completely dependent upon Russia. The fact that Russia later annexed them simply proves, after the fact, the level of control that Russia had over them. So you don't have to prove the specific act. When it comes to the Bosnian Serbs, the issue is really, the problem is this. When the Bosnian Serb Republic was created in 1991, 1992, I think then you could say really Serbia, Yugoslavia controlled them totally. They were completely dependent upon them. In 1995, which was when the Srebrenica genocide happened, it really wasn't like that. I mean, they said no to Milosevic all the time. And I think that's what led the ICJ to say, well, prove us the specific operation, and you couldn't, you know. So I think that makes sense. I understand your point about needing to prove global the global control the issue. By the way, same sort of issues arise again in the cyber context. The Wagner guy, the Prigozhin guy, we know of him even before Wagner. If you remember the 2016 hack of the American elections, the election interference that was run by these fake troll farms that controlled all the social media fake accounts on Twitter and Facebook, that was him operating a private company called the Internet Research Agency in St. Petersburg. And the issue again in 2016 when Donald Trump won, is whether Yevgeny Prigozhin's acts were acts of the Russian Federation. I'll finish here.
Well, I don't want to deprive Malgosia of time, but on one point I disagree with you. I don't think there are two Nicaragua tests. There is one, which is a control act by act, and the court was really grated and refused to accept that there was another one, which I call the Tadic test, which is precisely the global one. I think there is an opposition between both, and I am really resentful against the court for being so, what do you say, stubble, entêté, to stick to its absurd view. But well, again, there are two tests, and not. But one is Nicaragua and ICJ, and the other is Tadic and Cassel.
Well, thank you to everybody who's spoken. I think I will wait till the end to invite the audience because just because time is moving on, which I think reflects the fact that there has been a very good discussion. And so I'd like to invite our final speaker from the panel, Professor Malgosia Fitzmaurice, who will talk about environmental law.
I muted, I think. Okay, thank you very much. I prepared few PowerPoints because I have to start with general issue of the notion of environmental norm or obligation, because it is very connected to these issues of state responsibility. My part is also not very clear. So in relation to state responsibility, there is some case law. There is one very important case of the ICJ, but I will start with a sort of general description of main questions. My main research question today will be whether classical regime of state responsibility adequately addresses the issues regarding regime and wrongful lack of international environmental law. And then the question of reparation, whether the classical formula of Chorzów factory case, it's specifically can be applied to international environmental law. So the first question I would like to raise that we need to distinguish state responsibility from liability. So we have to distinguish the liability ex delicto, which is commission of a wrongful act, and sine delicto of acts, deleterious acts which result from lawful activities. I am going to focus today on the first category, but I would like to say that the International Law Commission noted the phenomenon that some acts can be lawful but cause deleterious results on environment. And in 1978, the International Law Commission started a project on articles on liability for injurious consequences of acts not prohibited by international law. In the end, this project morphed into articles from 2001 on prevention of transboundary harm from hazardous activities, which was later followed by 2006 draft principles on allocation of loss in case of transboundary harm arising from hazardous activities. So I will also not talk today about the compensation commission, which was set out after the Kuwaiti invasion, because this is a special case of responsibility in relation to, well, to armed activities, and the commission was based on the resolution of Security Council. I also will not talk about the responsibility of for the destruction of environment during armed conflict, which is the subject of articles of International Law Commission. Slides. So now I would like to start with some of the presentation of norms of international environmental law. So first of all, in relation to state responsibility, are the international obligations of conduct or of result? So the general view is that they are the obligations of conduct, which are determined by application of certain means, not the obligations of result. I would like to mention that this distinction is not included in article on state responsibility from 2001. And the Commission decided that not to include it because this distinction is really dependent on the content of primary norms. Now, the second point, which I think is very important, is that the duty to prevent transboundary harm is a duty of due diligence obligation, which is also based on the principle of non-significant harm caused to the environment. So in order to comply with due diligence obligation, states should put in place various domestic procedures in order to comply with due diligence obligations. So due diligence obligation is also a procedural obligation, and that was confirmed by the International Court of Justice in such cases like pulp mills, Costa Rica versus Nicaragua cases, where there were certain environmental procedures which constituted the procedural obligations, such as exchange of information, environmental impact assessment. Now we are coming to the important issue of bilateralism and multilateralism of relations between states in relation to environmental protection. So there is a view expressed in literature that international environmental law protects community of interest, i.e. The norms erga omnes and erga omnes partes are applicable. Therefore, what Professor Pellet mentioned, Article 48 of Articles of State Responsibility should be applicable. there is a case, whaling in Antarctic, and Professor Pellet was involved in that case, in which it was claimed that the Article 48 was operational, although in the judgment, the court never actually mentioned obligations erga omnes partes. The second time, explicitly, these obligations were mentioned. It was in relation to seabed dispute chamber advisory opinion by the International Tribunal on the Law of the Sea. However, I would say that the application of these norms in international environmental law is not exactly clear, and there are two approaches, one very wide, one very limited, that obligations erga omnes partes are applicable arising from treaties in relation to global commons or high seas, and the other which claims that all environmental obligations are obligations erga omnes, which is obviously debatable. So now we can move to the question, what is the which is very important in relation to state responsibility. What is the relationship between due diligence obligation and obligation of prevention, which is the main obligation underlying international environmental law? So in pulp mills case and Nicaragua, Costa Rica cases, it wasn't quite clear what the court meant by the obligation of prevention. So this also makes it quite open the questions of state responsibility in relation to violation of obligations of prevention and underlying obligation of due diligence. Now, as I already said, the main question is whether state responsibility provisions and reparations for environmental harm and the standard of Chorzów factory case is applicable to international environmental law in case of a wrongful act. So first of all, Article 35, restitution of status quo ante. So in relation to environmental protection, sometimes it turns out that harm is irreversible. So then the restitution is impossible. For instance, the species of animals are wiped out. The ecological damage is such that the restitution cannot be followed. So then what do? Then we come to compensation. So we are relying on financially accessible damage. In case of environment, such as the loss of biodiversity, RE non-use values are impossible to quantify. And another question is, what is proper notion of financially accessible damage in relation to extinction of wild life? Is it notional or a market-based value? So they are the problems which are very difficult in stating of, in following of articles of state responsibility. Now, in practice of the International Court of Justice, there is a very important judgment which follows Costa Rica, Nicaragua cases, i.e. 2018 judgment on compensation in these Costa Rica, Nicaragua cases. So the findings of the court were very important, although in the end, some of the points of the court were subject to criticism. So the court came to the conclusion that environmental damage is compensable under international law. However, the methodology of the decision and how the court arrived at this decision was subject to critique. Both states, Costa Rica and Nicaragua, came up with different ideas as to compensation of environmental damage. So Costa Rica relied on ecosystem services approach, damage to environmental goods and services which were given monetary value. And Nicaragua relied on replacement cost approach and in its written pleadings, and then on cost of preserving an equivalent area while the affected area was recovering. Then Nicaragua changed a bit its approach and related on corrected analysis in its oral pleadings, which basically was approach of Costa Rica, but with adjustment to categories of environmental goods and services included and the values added. The court disregarded both approaches and applied its own method of overall evaluation. And this method was based on overall evaluation of the impairment or loss of environmental goods and services, rather than based on value-specific categories of environmental goods and services and the time which it may take to recover. So, the court was basically, the court findings were subject to critique based on the approach that the methodology adopted by the court was very opaque, and that the calculation of baseline for prior environmental assessment and how to apply Hoju formula was really not quite clear in court findings. Another critique was why the court didn't use experts, and that went back to whaling case in which the use of experts was very wide. So I would also like to mention that there were some environmental compensation findings in investor states, exit arbitrations. I don't have time now to dwell on it, but on the basis of counterclaim, which was submitted by Ecuador, Ecuador was awarded 41 million for environmental damage. However, the basis for the adjudication was different from the International Court of Justice, and it was actually based on national law of Ecuador. Now, another venue which may be considered are human rights courts. There were several cases before the European Court of Human Rights, such as Lopez Ostra case, in which court was involved in stating the damage to environment and human life and health. So this is still a question mark, but the view is, and this is quite a well-received suggestion, that in the end, maybe human rights courts also should have some saying in responsibility for environmental damage. So I would say that in general conclusions that the classical regime of state responsibility probably is not fully equipped to deal with specificities of environmental law. Also, unclear content of environmental norm, i.e. relationship between prevention, also due diligence and other principles of environmental law, such as precautionary principle, make it very difficult to assess, to approach state responsibility. The relationship between substantive and procedural norms of due diligence and prevention also make it very difficult. So there is a general idea that the main principles of underlying environmental law are still very woolly, and it makes the state responsibility very difficult to approach and to assess. So also how to assess compensation, how to approach non-use value, i.e. intrinsic value of the environment, and how to include equitable approach to state responsibility. So they are the still questions to be resolved. The practice is very scant. There is really only one award of judgment of the International Court of Justice, which deals with the question of with compensation for environmental damage. Probably the interstate arbitrations are not very useful in this respect. So we are still waiting for some consistent practice, and probably also waiting for more well-defined norms underlying international environmental law. Thank you.
Well, thank you, Professor Fitzmaurice, for your very expert discussion of developments in international environmental law. I'd like to just make a few, as the discussant, I'm officially the discussant. There's really too many issues and points covered to draw it all into single one or two issues. But one issue that I did think cut across the papers to some extent, the presentations to some extent, was a point raised by Professor Pellet about how Special Rapporteur Ago reconceived state responsibility as having a more community and objective dimension. And so that was one of the things that I picked up on from his presentation, that, if you like, were of more lasting significance or more general significance. And I think possibly that I'd be very interested to hear more about what Professor Pellet thinks about the draft articles and the international responsibility of international organizations, and whether his concern or critique of the transfer of more or less the same norms about states to IOs is related to the fact that there are different levels of responsibility and different levels of commitment of countries to international organizations. Has it to do with being able to define the extent of the integral or multilateral commitments in different international organizations? Something like the EU might be suitable for a transplant of the rules and state responsibility, but maybe lots of other international organizations are not so suited. I wonder if that's something to do with his concerns about that. And I think that issue, I suppose, arises in the second presentation of Professor Milanovic, just from the fact that there were two applicant countries in Netherlands and Ukraine v. Russia, and how two countries were able to bring a joint case under the European Convention on Human Rights, and how widely is the practice of joint claims under the convention? Is it something that's emerging? Is there a greater awareness of the shared or community dimension of human rights, or was it a very particular case in that sense? And in international environmental law, the traditional idea of kind of clear bilateral obligations between states from treaties. I mean, there's always been customary rules that have been multilateral or more communitarian, I suppose. But even more so in international environmental law, it's harder to think of the law as being even mainly about bilateral obligations. It has a much more international, multilateral, or community aspect to it. I think that's relevant to the idea that due diligence is still poorly defined in international law. And maybe if I could just start off the questions by asking a specific question about that. Could you say that there is a customary norm to any extent about substantive due diligence, or is it all based on various treaty obligations? And what are the prospects of developing or recognition of some customary norm of due diligence in international environmental law? So maybe to start off questions with that. But thank you to all the speakers. It's been a very rich discussion of many aspects of international law.
Maybe the question in general, I understand Dr. Conway's question in general. So if any of the speakers want to address due diligence and international law, the floor is yours. I understand that, Dr. Conway, this was your intention.
Yes, I really wanted to start this question with Professor Fitzmaurice because I thought it would be easiest for her to, well, it was a more specific question, and I thought it would be good to start off with general questions with that. But yeah, I start with that.
Also, Professor Pellet also wants maybe to take precedence. So okay. Maybe Professor Pellet.
Yeah, whoever would like to speak first, I think.
Dr. Conway, you can mute after yourself in order for the echo not to exist also in the discussion.
I don't know. I can wait. My question is rather precise. I really enjoyed what Malgosia said, and I must say I share what she said 100%, or maybe only 99%, if she is a great admirer of the two ILC drafts on liability, because personally I am not. I think I have explained several times during the discussion that for me it was decaffeinated coffee, and I prefer strong coffee than decaffeinated one. And in particular, I know that she has written a book which I have not read, I must say, but on I think it was dedicated on the last slide on the principle of precaution, and I think it is an absolute scandal that it has not been evoked in the P.S. Rao's, my good friend P.S. Rao's draft. So I just wanted to be sure that she doesn't like the draft, because I think they're very poor.
Professor Fitzmaurice, you can go on. Yes.
Yeah, I would like to say that I am not a great admirer of this liability draft, but I thought I have to included in order to make a methodological division between state responsibility and state liability. It is there. We need to talk about it. However, I find it still methodologically not very clear how actually it came about. And maybe Professor Pellet can say how actually it happened that the International Law Commission has taken up this draft on injurious consequences of non-wrongful acts, because methodologically it was quite criticized. And then this hazardous draft on hazardous liability for hazardous activities is basically, in my view, well, a little bit redundant, because we have civil liability regimes for instance, nuclear liability conventions, convention of oil pollution, when it is civil liability underlying civil.
Sorry, but is it liability or is it not then responsibility?
It is only liability of a private individual, and we are here talking.
Okay.
Yeah, it is a liability. But the draft of the International Law Commission in the end goes down to an operator. So it is the same principle which underlines all pollution liability regimes and nuclear liability regimes. So I am not quite convinced that this draft of the International Law Commission added much. Maybe it added the principle of prevention, because it's all based obviously on principle of prevention, no significant harm. So it put together probably the principles underlying general international environmental law to liability. But always the most important place, I think, question is who is liable, right? Who is responsible? And in multilateral conventions and in the draft of the International Law Commission, it boils down to an operator. Do you agree with me, Professor Pellet?
I do. Well, you should call me Alan, as we usually do. I do, and I must say that one of my main objection to the ILC draft was that I thought that there was room for precisely responsibility to go from liability to responsibility. I think when a state does not force the operators to implement the principle of precaution, then we should go from liability to strict responsibility. And this, my very prudent Indian colleague could not accept, and there were a strong fight, but I fully agree with you. Again, I really could endorse everything you said, and on the difference between the law of state responsibility and the general law of liability, which is something less easy to understand for a classical international law mind as mine. But now I think I totally accept this.
Professor Fitzmaurice, thank you very much also from my part about the presentation. Two brief questions, one which is very kind of eccentric in order to link with Professor Milanovic's presentation. Professor Milanovic questioned the ability of the European Court of Human Rights to enter the whole framework of the international courts. And along these lines, he posed maybe the other perspective, how human rights courts can have a positive contribution to the configuration of environmental law. So do you think, or do we think also, Professor Milanovic, that when it comes to human rights courts, maybe they have a double function. They can be destructive in one sense and more constructing on another field. This is the first question. And the second one, I will return to what I asked also Professor Pellet before, whether you think that environmental law can be a pilot when it comes to mental harm, civilian mental harm and warfare, and whether you think that liability can be established there in these cases based on the precedent of environmental law. And about externalities, what I asked before also. So thanks.
Yes, to the first question, which kind of appeals to me more than the second question, I think, as I am not an expert on general human rights or mental health, but I will try. I think that human rights courts now are expanding, and they are encompassing wider range of issues in relation to human rights and the environment. And I think that the trend was already culminated in July 21, when the General Assembly announced that there is a universal right to human right to environment. And I think that before, I would like to sort of specially signal advisory opinion of the Inter-American human rights in relation to human right and environment, when first of all it acknowledged under some limited but still acknowledged possibility of extraterritorial applicability of human rights, but also related to general well-being of a person, and evolutionary interpreted certain provisions, provision 26 to be precise, in the Inter-American Convention on Human Rights, as giving the ground to human right to clean environment. And it also included prevention principle, precautionary principle into the debate. So I think that I would answer the question like that. There is a general possibility of human rights courts dealing with responsibility for environmental damage insofar as it encroaches on human rights. But then we have the practical issue, which I illustrated by 2018 ICJ case on compensation or restitution, which I think possibly it would exceed the human rights court's capacity, I think, to define, because it's a very specialist area. And even ICJ, which is a very general classical court, has been subject to quite fundamental critique after the judgment. So it may happen. It was one, I think, in maybe one case which was against Russia, that the court tried to make some monetary statement in relation to the claimant, which was a Russian woman, which was whose health and well-being was affected by environmental damage. However, I think that per se, environmental damage would be very difficult to define by human rights courts. I think it's not really a compensation for environmental damage. It's connected to compensation for breach of human rights, I think. So it is different. Now, as far as the questions of health are concerned, there were cases before the European Court of Human Rights, like this Lopez Ostra case, Budayeva versus Russia. And also the Human Rights Council appointed a special rapporteur, Professor Knox, who spent quite a long time linking also health issues to environmental issues. So I would say that there is a definite nexus between all the elements, but it's very broad. It's sometimes very difficult to define. And I must say, not only me, but other colleagues who are environmental lawyers, we have difficulties in broadening now of the subject, because it's a very good question. It's extremely difficult to be now purely environmentalist, purely ecologist, human rights, it's all connected, but which direction are we going? How far can we go? How broad can it be? Is it now blurred division between human rights and environment? Possibly it is, I think. And now we have a new question, which I think also will impact on state responsibility, right of nature. So not only right of human being, but right of nature. And in December last year, so very recently, Conference of the Parties of the Biodiversity Convention explicitly acknowledged rights of nature and Mother Earth. And in many jurisdictions like New Zealand, for instance, Ecuador, Bolivia, there is already constitutionally accorded right of nature itself. And there is personhood of rivers, for instance, and mountains. And how does it relate to state responsibility? It will, because there were already cases before national courts for damage to river. And river as a person was represented by trustees. So I would like just to show the very robustly developing area of state responsibility in relation to environment. Environment is the fastest growing, I think, area, and possibly it will make very difficult decisions in relation to international law approaches to damage to environment in relation to environment and human rights and health.
Dr. Conway, maybe we can actually say that we have also a question in the audience.
Yes.
But it's a bit of a general question. Maybe we can read. It's about the war in Ukraine, the outcome of the war. I don't think that our experts can answer this question, but in all cases, maybe to address it.
Yes, I can't see the question in my chat, but maybe whoever.
So yes, I will read very quickly the question. It's for all the speakers: how to solve the Ukraine-Russian war, peace talks, fighting to the mutually destructive Armageddon endgame between Ukraine, West, and Russia. And it's a very general question about the end of the war in Ukraine. And along these lines, it doesn't relate specifically to issues of international responsibility. I would like to say to our dear participant that maybe this cannot be addressed by the members of this panel, because it's also a political-oriented question. But in all cases, we read it aloud. We respect, of course, we welcome all questions. And if any of the participants wants, nevertheless, to take the bid, we are here in order to hear any potential answer. Otherwise, for my part, because also the time has passed and was very enjoyable discussion from all the parties, to say to everybody, and of course, Dr. Conway will have the final word to close the event, to say to everybody, to thank the speakers also from the part of the BUL International Law Group, to say that the group organizes its next event on religion and international law on March the 8th, and we look forward to seeing you also there. With this, for my part, I leave you to General Gerard Conway's final words. And once again, thank you to all the speakers. Dr. Conway, the word is yours.
Well, thank you to Solon for chairing the event and for helping organize it. And but most of all, thank you to our speakers who are all very busy and who've taken over 2 hours of their time, apart from preparation they did. We've had a very wide-ranging and rich discussion, and we've had 20 attendees who have been here for the full 2 and a bit hours. So I think that says something about the discussion. So I hope to be in contact with you all again. And I'd like to thank, well, you again, and also the audience. And hopefully we will see each other again at another event.
Thank you very much. It was our pleasure.
Thank you. Goodbye.
Bye. Bye.